Hatch-Waxman Act এর আগে শুনেছো এটার সম্বন্ধে কেউ কিছু?
No, sir.
Okay, because why I am asking, because some of you already you have taken some training from some pharmaceutical industries, so this is very important part, that Hatch-Waxman Act. So today we'll study about that. What is this? In this topic we will cover what is the objective of this act, what is the various provision of this act, then paragraph 4 filing, that means how to file, and then the reason behind the delay in generic entry, and the loopholes of this Hatch-Waxman Act, and finally conclusions. Now, for example, one drug that is discovered today, when it will come into the market, how much time it will take? Today, one drug is discovered, new drug entity. When it will come into the market, how much time it required? Any idea? কতটা সময় লাগতে পারে? কোনো একটা ড্রাগ জাস্ট ডিসকভার হওয়ার পর কতদিন পর সেটা মার্কেটে আমরা পাবো?
ম্যাম স্যার মোটামুটি 10-15 বছর তো লাগে।
মিনিমাম 10 to 15 years, almost 15 years. So
Yes, sir.
yes, and patent, all of you know, পেটেন্ট একটা যদি কোনো কিছু ড্রাগের উপর বা প্রসেস পেটেন্ট বা এপিআই এর উপর যদি কোনো কিছু একটা পেটেন্ট থাকে, হোয়াট ইজ দ্য টাইম ইট উইল টেক? পেটেন্টের কতদিনের সে রাখতে পারে? কেউ একজন ধরো পেটেন্ট পেলো, ধরো আমি একটা পেটেন্ট পেলাম, তো আমি সেটা সেই পেটেন্টটা আমি কতদিন ধরে
20
রাখতে?
years.
ভেরি গুড, 20 years. So that means, what is the meaning of that? During these 20 years, that is not possible to test or to prepare any type of dosage form by taking that especially that API, and that is not possible. Why? Only after completion of 20 years patent term, when it will complete it, after that only you will be able to test that drug, or you will be able to do some research and development work. So it's a very time consuming. So that is the main loopholes of that patent. See that আমরা যখন আগে আগে পড়বো আমরা বুঝতে পারবো কি why this Hatch-Waxman Act is required. This act is known as the Drug Price Competition and Patent Term Restoration Act, which is enacted in 1984 and amendment the patent law, and also amended the Federal Food, Drug and Cosmetics Act. Already all of you have studied Food, Drug and Cosmetics Act in pharmaceutical jurisprudence. The same here also, this Hatch-Waxman Act, that is also known as the Drug Price Competition and Patent Term Restoration Act. Already I have given one example in last I think last 2-3 classes. Before that I have already given one example, that azithromycin, when it came into the market, initially the price was 99 rupees, and now if you see that price is 57 or 58 rupees. So why? What is the reason behind this? Why after a few days the price that has been dropped? Because of this one. Okay, because the patent that is completed, and after that the price that has been dropped. So the Drug Price Competition and Patent Term Restoration Act. Okay. Before 1962, the new drug approved that was completely based on safety. Okay. Before 1962, when one new drug that came into the market that was approved by FDA or any other approval body, that completely based on safety of that particular API. After that, proof of efficacy made compulsory for marketing approval of a new drug. That is known as Kefauver-Harris Amendment. Okay? that come after 1962. There was no provision for patent term extension prior to enactment of the Hatch-Waxman Act. প্রত্যেকটা কথা ভালো করে শুনবে তাহলে বুঝতে পারবে এটা। So to make up for the time lost out of the total patent term during the marketing approval process. বুঝতে পারলে কথাটা? There was no provision for patent term extension prior to enactment of the Hatch-Waxman Act to make up for the time lost out of the total patent term during the marketing approval process. অনেকটা সময় নষ্ট হতো। So because of that, generic companies required to submit their own comprehensive data to the NDA, which is very much costly and time consuming also. And in that case, if the drug was covered by patent, then testing of that drug would not begin until patent expired. That is big problem. So to overcome the above problems, an act was needed, which is known as Hatch-Waxman Act. What is the role of this act? To promote generic companies. দেখতে পাবে এখন ওই প্রত্যেকটা গভর্নমেন্ট থেকে একটা করে নতুন করে একটা রিটেল শপ ওপেন হচ্ছে, যেটা কি নাম বলো তো, বলতে পারবে তোমরা? মেডিসিন শপ, রিটেল শপ ওপেন করছে গভর্নমেন্টের তরফ থেকে। সেখানে যদি তুমি যাও, একটা ওই অ্যাজিথ্রোমাইসিন তুমি যেটা মার্কেট থেকে অন্য কোম্পানির 58 রুপিসে কিনবে, সেম অ্যাজিথ্রোমাইসিন ওখানে কিন্তু অনেক কম প্রাইসে পাবে। আমি ভুলে যাচ্ছি ওটা
জনঔষধি যোজনার আন্ডারে যেটা।
ইয়েস 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 ইয়েস, জনঔষধি কেন্দ্র। ভেরি গুড, জনঔষধি কেন্দ্র। তো ওখানে যে কটা তুমি দেখবে, ওখানে কোনো মার্কেট নাম নিয়ে কিন্তু কোনো মেডিসিন কিছু নেই, তবে যেটা জেনেরিক নেম সেটাই তার মার্কেট নেম, ঠিক আছে? সেখানে সেই নাম দিয়েই তুমি পাবে। তাহলে তার অ্যাডভান্টেজটা কি? যে আমাকে বেশি দাম দিয়ে আমাকে সেই মেডিসিনটা কিনতে হচ্ছে না। ওকে, so to overcome the above problem, an act was needed, which is known as Hatch-Waxman Act, to promote generic companies. So what are the objective of this act? Why it is required? The first objective is reducing the cost associated with the approval of a generic drug. For example, today in lab, one new drug entity has been discovered, and after that, so many tests is required, so many documentation is required, and every safety, efficacy, and the test result, bioequivalence studies, everything, every detail, then clinical trials data. If that is any non-clinical studies is there, then non-clinical data, everything that you have to properly submit to the authority. That means USFDA or MHRA, like that, or TGA. So after getting approval only, you will be able to prepare the dosage form. So this Hatch-Waxman Act, the main objective is reducing the cost which is associated with the approval for a generic drug, and it also allowing early experimental use. For example, today the drug has been discovered. After 1 month, you can start with the different types of test and experimental procedure you can proceed. Another one objective, that is, it will compensate the branded drug manufacturer for the time lost from the patent term because of the regulatory approval formality. এই যে দেখো আরো একটা এখন দেখতে পাবে যে এখনো পর্যন্ত দেখো মার্চে আমাদের লকডাউন হয়েছিল, তাই তো? তাহলে সেই সময়তে যে ভ্যাকসিন তারপরে তৈরি করতে শুরু করেছে, কিন্তু এখনো পর্যন্ত মার্কেটে এলো না। আমরা নিউজে জানতে পারছিলাম খুব তাড়াতাড়ি এসে যাবে, খুব তাড়াতাড়ি এসে যাবে। তাহলে কেন আসছে না? হোয়াট ইজ দ্য রিজন বিহাইন্ড দিস? অনেক সময় ক্লিনিক্যাল ট্রায়াল ফেজ 1 পাস করলো, অন্য কোম্পানি দেখা যাচ্ছে ফেজ 1 ফেল করলো, আর একটা কোম্পানিতে দেখা গেল ফেজ 2 পাস করে গেল, আর একটা জায়গায় ফেজ 2 পাস করলো না, সঙ্গে সঙ্গে তার সাইড এফেক্ট এত দেখা গেল যে সেইখানে কি কিন্তু সেই ফেজ 2টাকে স্টপ করে দিতে হলো। তো একটা টাইম কনজিউমিং ব্যাপার, যে কারণেই এত দেরি হচ্ছে। এখনো পর্যন্ত আমরা জানি না যে কবে করোনার ভ্যাকসিন আসবে। তো সরি, so what is the reason behind this? That is because of the regulatory approval formality. Some formalities are there, you have to fulfill all that formality, then only it will come into the market. Another one objective, that motivating the generic drug manufacturer. তাহলে এতে লাভ কাদের? পেশেন্ট, যারা ইউজ করবে সেই মেডিসিনটা, কারণ সেটা প্রাইসটাও কম হবে এবং আমি পিওর ড্রাগটা আমি পাবো। So this Hatch-Waxman Act strives to strike a balance between the interest of branded drug manufacturer and generic drug manufacturer and the consumer. Okay, so that is the main objective of Hatch-Waxman Act. Okay, got my point? Then what are the various provision of that act? কি provision আছে? আচ্ছা, এগুলো কি বলতো, এটা এই যে টপিক গুলো দেখবে এরপরে আরো সব আছে, এনডিএ তে কিভাবে করতে হয়, ডোজিয়ার কিভাবে, হাউ টু প্রিপেয়ার ডোজিয়ার, হাউ টু প্রিপেয়ার ডকুমেন্টেশন ফর সাবমিশন টু দ্য এনডিএ, অ্যাপ্রুভাল, ড্রাগ অ্যাপ্রুভাল প্রসেস, এগুলো সব একটু বোরিং টাইপের, এবং এটাকে তুমি যদি মাগাপ করতে যাও তাহলে কিন্তু মাথা যন্ত্রণা ধরে যাবে। জাস্ট তোমাকে মানে সুন্দরভাবে বুঝে নেবে, তাহলে কিন্তু তুমি নিজে লিখতে পারবে। আর কয়েকটা জিনিস জাস্ট ইউ হ্যাভ টু রিমেম্বার। For example, this one, see that the first provision of this act, it was created on section 505J. এইগুলো একটু মনে রাখতে হবে, যেমন তোমার ফার্মাসিউটিক্যাল জুরিসপ্রুডেন্সে কোন অ্যাক্ট কোন ইয়ারে পাস হয়েছিল সেটা যেমন মনে রাখতে হয়, তেমনি এরকম। So this section 505J, that is established the ANDA approval process. Okay, so section 505J, if you open, so you will get the under approval process. The timing of an ANDA approval completely depends in part on patent protection for the innovator drug. New drug application must include any drug or a method of using the drug for which a claim of patent infringement could reasonably be ascertained. What is the meaning of this patent infringement? Any idea? Patent আমরা জানি যখনই আমরা পেটেন্ট পাবো সেই পেটেন্টটা 20 ইয়ার্স অবধি থাকবে। What is the meaning of that patent infringement? Any idea? Patent infringement.
No, sir.
Patent infringement means, যেমন ধরো, according to law, everything that I have submitted. Now, এখানে যেটা আমি বললাম, that strikes a balance between the interest of branded drug manufacturer and generic drug manufacturer and the consumer, and also to start the test immediately. This Hatch-Waxman Act that has been published. Now, patent infringement means যে পেটেন্টটা অলরেডি অ্যাপ্রুভ হয়ে গেছে, সেই পেটেন্টটাকে যদি আমরা ব্রেক করতে চাই, ধরো আমি যেমন ব্যাংকে হয় না, আমি 10 বছরের জন্য এককালীন আমি একটা টাকা রাখলাম, ঠিক আছে, যেমন ফিক্সড ডিপোজিট যেটাকে বলে। তারপর আমি কি করলাম, 10 বছর কমপ্লিট করলাম না, তার আগেই আমি কিন্তু সেখান থেকে সেই ফিক্সড ডিপোজিটটাকে ভেঙে দিলাম, ব্রেক করে দিলাম, ব্রেক করে দিয়ে আমি 5 বছর পরে আমি টাকাটা তুলে নিলাম। এটাকে বলা হচ্ছে যেমন ধরো ইনফ্রিঞ্জমেন্ট। তো সেম হিয়ার অলসো patent infringement, that is asserted. That means before completion of the time period, you have to break that patent. So on approval of NDA, FDA publishes patent information for drug in one particular book. That book is known as Orange Book. এটার নাম অনেক সময় শুনে থাকবে। What is Orange Book? Orange Book এটা মানে এটা নয় যে এটা অরেঞ্জ কালারের হবে। Okay, Orange Book means that book contains the list of approved drug products with therapeutic equivalence evaluation. Okay, that is the list of drug. Orange Book contain the list of approved drug products with therapeutic equivalence and evaluation. Now, see that. What is the Orange Book in details? This Orange Book that is published by Food and Drug Administration, FDA, they publishes patent information on approved drug products in the Orange Book. An NDA applicant, they must submit some information, important information for one particular patent. For example, patent number, date on which the patent will expire, what is the type of patent, that means that is drug patent or product patent, or method of use. That means you have patentee, they have taken patent only for method. Some products are there the patent only for design or patent only for drug, like that. Then the name of patent owner and the name of an agent of the patent owner or applicant. All this information that you have to submit to the FDA. Brand drugs listed for generic to compare with their proposed product. It is also mentioned into the Orange Book. That is brand drug listed for generic to compare with their proposed product. Now, different types of patent certifications are there. Generally, 4 types are there. When an applicant submits an ANDA to the FDA, the applicant must certify one of 4 things under this section 505J 2A and 7. What is that 4 things? First one is the required patent information which is related to such patent has not been filed. এখনো পর্যন্ত সেটার কোনো রকম কোনো কিছু patent file হয়নি. Second one is such patent had expired. কোনো একটা সেরকম patent expired হয়ে গেছে. That the patent will expire on a particular date and that such patent is invalid or will not be infringed by the drug for which approval is being sought. Okay, so these are the 4 things. So to get patent, when an applicant submit an ANDA to the FDA, that applicant must certify one of these 4 things under this section. So see that I have mentioned here para 4. So what is the meaning of that para 4? Para 4 means patent challenge. Here I have mentioned such patent is invalid or will not be infringed by the drug for which approval is being sought. That is according to the paragraph 4, that is known as patent challenge. The patent challenge, what is the process? See that for generic drugs, para 4 filing. For generic, provide notice to the brand within 20 days of acceptance. Okay, 20 days of acceptance. Brand that must bring lawsuit within 45 days. And in cases of generic, if sued, then automatic 30 months stay granted to the brand. এটাতে আরো ক্লিয়ার হয়ে যাবে দেখো for one generic manufacturer, first they will warn the brand name manufacturer or innovator. That means they will explain the existing innovator patent is invalid or will not be violated by the generic. When they will warn, in reply they will tell that innovator can file a patent infringement lawsuit even if authentic claim by the generic manufacturer. And in reply, if it is filed within 45 days, then FDA does not give approval to the generic for a period of 2.5 years, 30 months. And if filed after 45 days, then no action by FDA. Okay. So after completion of 2.5 years, that means 30 months, what will happen? After 2.5 years, US FDA decide if it should grant approval or not. Okay, so that is the process. Then, what are the various incentives and protections about this law? First one is 180 days market exclusivity. It is very much important. First applicant to submit a substantially complete ANDA, first to file, and it may be shared by multiple applicants. Okay, and it is subject to forfeitures. Second one is 30 months stay of FDA approval. If patent owner or NDA holder, they sues the ANDA applicant for patent infringement within 45 days. যেখানে দিনগুলো এগুলো হচ্ছে ইম্পর্টেন্ট within 45 days of receiving notice of the paragraph 4 certifications, then 30 months stay of FDA approval is required. It runs from the date of notification or expressions of NC exclusivity. It may be lengthened or shortened by the court. This is 30 months stay of FDA approval after getting approval. Then notification letter. For notification letter, it will take 20 days. Upon ANDA acceptance for patent filing, the applicant must notify the NDA holder and patent owner of the ANDA within 20 days. The notice that must include a detailed statement of the factual and legal basis of the opinion of the applicant that the patent is invalid or will not be infringed. Okay, that is known as notification letter. That upon NDA acceptance for filing, the applicant must notify to the NDA holder. Then lawsuit, it will take 45 days. After getting notice, upon notification, the NDA holder and patent owner, they have 45 days time. In this time, they have to initiate an action for patent infringement. If such an action is brought within 45 days, then ANDA is subject to a 30-month stay of FDA approval, beginning on the date of the notification letter was received. Whatever I told here, that is described here. Okay. Now, this is one survey, that is ANDA approval. See, year-wise, this survey, from that we can know that in the year of 1999, the original ANDA receipt, that is how much, and approval, how much receipt that got approval. This is yellow color border. So year-wise, we can see that that is the ANDA approval. That is another one, ANDA approval for Indian companies. See that here 5 companies are there: Glenmark, Aurobindo, Sun Pharma, Lupin, DRL. I think some naam sune chhe. So all these are Indian companies. Now see that here 2 years survey is there, 2009 and 2010. Indian companies bagged 33.17% or 139 of total 419 original ANDA approval from US FDA in 2010. Okay, you can see the details from this source. This is the source. So next, what about the exempt act of patent infringement for FDA approval? What is the exempt act? Exemptions from this act: the manufacturer, use, or sale of a patented drug that is not an act of infringement to the extent it is necessary for the preparation and submission of an ANDA. This Hatch-Waxman Act provide under 35 USC and the law, that is according to this section 271E1. It shall not be an act of infringement to make, use, or sell a patented invention solely for uses reasonably related to the development and submission of information under a federal law which regulate the manufacture, use, or sale of drugs. That is the exemption of this Hatch-Waxman Act. So, according to this law, what is the benefit for branded manufacturers? Because if it is generic, then obviously the price that will be dropped. So, what will be the benefit for branded manufacturer? First benefit: Orange Book provides the public notice of patent, and it also allows for resolution of patent dispute prior to generic entry. And another one benefit, that is 30 months stay of FDA approval of generic drugs. And patent term restoration is possible. And it also allows for several market exclusivity. For example, data exclusivity, 5 years for new chemical entity drug and 3 years for non-new chemical entity drug. For orphan drugs, market exclusivity year, that is 7 years, and for pediatric product 6 months. So all these are the benefits for branded manufacturer. So what is the benefit for generic manufacturer? For generic manufacturer, 180 days market exclusivity for first successful challenger to the Orange Book patent, and it also allows generic to challenge Orange Book patent without risk of damages. Okay, see that here one example I have given. Dr. Reddy It was the first Indian company to get the 180-day exclusivity for marketing fluoxetine. Okay, in Eli company, the market name that is Prozac, that contain fluoxetine 40 milligram capsule in August 2001. Okay. Here, another one rule is there, safe harbor rule, which allows generic to perform bioequivalence and other testing which is related to regulatory approval without risk of patent infringement. Because without when you will go for any testing of that particular drug, there may be chances of a risk of patent infringement. So the safe harbor rule, which allows generic to perform bioavailability and bioequivalence studies and clinical studies and other testing which is related to regulatory approval without risk of patent infringement. So what গুলো মনে রাখতে হবে? Safe harbor. Next, non-patent exclusivity. এতক্ষণ যেগুলো দেখলাম, that is all a patent exclusivity. Now, non-patent exclusivity. What is the various types and what is the terms? For new chemical entity, it will take 5 years. For new clinical studies, 3 years. For orphan drug, 7 years. Pediatric exclusivity, 6 months. And 180-day generic market exclusivity, that is 180 days. That is about various non-patent exclusivity. So, new chemical entity, NCE exclusivity, that is according to the Act Hatch-Waxman Act 1984, which is granted, that is to the drug products containing a new chemical entity, which also that is submission of according to this subsection 505(b)(2) or ANDA. And how much time it required? 5 years. Okay, or 4 years if paragraph 4. What is the definition of new chemical entity and active moiety? What is the difference, basic difference, and what is the definition? New chemical entity means a drug that contains no active moiety that has been approved by FDA in any other application submitted under the section 505(b) of that act. That is known as new chemical entity, which contains no active moiety. The new chemical entity means that may be some excipients which is having no active moiety. The active moiety means the molecule or ions excluding those appended portion of the molecule that cause the drug to be an ester, salt, or other non-covalent derivative such as complex, chelate, or clatrate of the molecule, which is responsible for the physiological or pharmacological actions of the drug substance. That is known as active moiety. So, new chemical entity exclusivity for enantiomers. Enantiomer. So, Federal Drug Administration Amendment Act 2007, FDAAA. According to that, under strict condition, an enantiomer can qualify as a new chemical entity. Enantiomer কেও কিন্তু আমরা new chemical entity বলতে পারি. In which condition? Under strict conditions. The single enantiomer has not been previously approved except in the approved racemic drug. Racemic drug mixture. So the NDA includes full new clinical investigations, and the clinical studies are not used for the racemate, and the enantiomer indication is not in the same therapeutic category as the racemate. And in this case, 3-year exclusivity is available. For example, esomeprazole, that market name is Nexium, and escitalopram, that is the generic name, and market name is Lexapro. NCS exclusivity, new clinical study exclusivity, that is total time it will take 3 years, and that is according to the approval of 505(b)(2) or ANDA, and this is granted for submission of result of new clinical studies. New clinical study exclusivity, and that is according to the Hatch-Waxman Act 1984. The granted for submissions of reports of new clinical investigations, which is other than bioavailability studies, that you have to mention. which is essential. হ্যাঁ অঙ্কিত বলো। কিছু বলবে?
ভুল করে হয়ে গেছে, সরি স্যার।
আচ্ছা আচ্ছা আচ্ছা। গ্রান্টেড ফর সাবমিশন অফ রিপোর্টস অফ নিউ, কারো একটা মাইক অন আছে মনে হয়, দেখো তো আওয়াজ আসছে কি?
Dibyendu Das, mute your mic. Dibyendu Das, please mute your mic.
আমি এখান থেকে
দিব্যেন্দু মিউট কর।
বুঝতে পারছি না আমি কার অন আছে।
হ্যাঁ স্যার, ওই দিব্যেন্দু দাস আমি বুঝছি, এখান থেকে শো করছে।
সো
অনিরুদ্ধ একটা মেসেজ করে দাও ওকে।
so new clinical
হ্যাঁ
study,
করে দিচ্ছি।
it is granted for submission of reports of new clinical investigations. Now here you have to remember clinical investigation which is other than bioavailability studies. Okay, bioavailability spelling mistake আছে এখানে, which is essential to the approval of the applications, in brackets see that, or the supplemental applications and conducted or sponsored by the applicant. Okay, that is new clinical study exclusivity. Here I have given one example, so it will be clear for you. New or changed formulation, for example salt, for example ephedrine and ephedrine hydrochloride. So ephedrine, that is a pure drug. Ephedrine hydrochloride, that is a salt form. আমরা ফিজিক্যাল ফার্মেসিতেও পড়েছি না যে সল্ট ফর্ম আমরা কোন সময় ইউজ করি, ধরো সলিবিলিটি বাড়ানোর জন্য, বা ডিফারেন্ট রিজনস আর বিহাইন্ড দ্যাট. So if we use salt, so you have to indicate that what is the dosing regimen, patient populations, OTC switches or other level changes. Example here I have given, see that one name, immediate release to extended release. One drug that is available in the market as a form of immediate release tablet, now I want to prepare for the same drug entity, that is extended release tablet I want to prepare. So in that case study is required. So in that cases some new clinical study exclusivity is there. So example here, Caduate, atorvastatin or amlodipine combination, that is another one example of new clinical study exclusivity. For example ধরো atorvastatin আর amlodipine দুটো একসাথে আমরা দিতে চাই, সেটার জন্য আমি ভাবলাম আর দিয়ে দিলাম তো হবে না. So you have to do some experiment, some clinical study, some non-clinical study, whatever, bioequivalent studies. যেমন ধরো অ্যাডোভাস্টিনের যা ডোজ, অ্যামলোডিপিনের যা ডোজ, দেখা গেল যে দুটোর যে সাইড এফেক্ট, আমরা দুটোরই যদি সিঙ্গেল সিঙ্গেল দিই তাতে যে সাইড এফেক্ট দেখা যাচ্ছে, ইফ উই গিভ ইন কম্বিনেশন ফর্ম বাই ডিক্রিজিং দ্য ডোজ, দেন ইট উইল বি বেটার ফর পেশেন্ট. সো এই ধরনের আমি ধরো আমার মাথায় একটা চিন্তা এলো, তো আমি সেটা নিয়ে কাজ করছি সেটার উপর. সো উই হ্যাভ, যখন আমি গুড রেজাল্ট পেলাম তখন আমাকে আই হ্যাভ টু অ্যাপ্লাই টু দ্য FDA to get that approval. Next, for orphan drug. Orphan Drug Act, that is also known as, that is passed in 1983. It is granted to drugs intended for treatment of a rare disease or condition. Orphan drug, এর আগে তোমরা পড়েছো এটার ব্যাপারে পলিটিতে, that is drugs which is intended for treatment of a rare disease or conditions which affect less than 2 lakh people in the US, or no reasonable expectation or of recouping uh, divisions cost, which blocks of this subsection 505B1 or B2 or ANDA directed to the same drug for the same disease. Okay, and it will, the time required for that, that is 7 years. That is the length of exclusivity of a drug. And additional your tax credit, grant, fees, all are waived for this drug. Why? Because that drug that is intended for rare disease or condition. That's why this additional rewards, that is only for orphan drug. For pediatric or any other drug, that is not, this additional reward is not possible. Next, pediatric exclusivity. For that time already I have given, I already told that 6 months beyond any existing marketing or patent exclusivity, blocks, that is approval according to 505B2 or ANDA, and government funding or pediatric studies if no exclusivity is there, and that is according to FDAMA, Food and Drug Administration Modernizations Act 1997. Okay, which granted to applicants who successfully complete FDA requested clinical trials of a drug in a pediatric populations. That's why time is very much short. That is only 6 months beyond any existing marketing or patent exclusivity. Then generic drug exclusivity. That will take length 180 days from commercial marketing. Approval of subsequently filed ANDA containing a paragraph 4 certification is required. It is first granted to first ANDA applicant who submit a substantially complete ANDA containing a paragraph 4 certifications. That is related with generic drug exclusivity. Next, 180 days exclusivity for features. That is Medicare Modernization Act, that is also known as MMA, Medicare Modernization Act, which is passed on 2003. 6 ways to forfeit. First one is failure to market. Second one, withdrawal of applications. Third, amendment of certifications. Failure to obtain tentative the listed drug applicant holder or a patent owner. And sixth one is expirations of all patent. So all these are the 6 ways to forfeit to get that 180-day exclusivity for features. Okay, so this is all about in details of this act. Then there may be possibility of delay in generic entry. So what is the reason behind that? The total 5 points are there. See that reverse payment agreement, some litigation, that is 30 months stay. Already we have seen that. In cases of FDA, it will stay for 30 months. Then some citizens petitioning. Actually, এগুলো একটু বুঝতে একটু হয়তো প্রবলেম হতে পারে কি হোয়াট ইজ দ্য মিনিং অফ দ্যাট সাম সিটিজেন পিটিশনিং, এগুলো পরে আরো ডিটেলসে আসবে, তখন বুঝে যাবে। নেক্সট, ওয়াকার প্রসেস ফ্রড or product hopping. All these are the 6 reasons behind delay in generic entry. What is the meaning of reverse payment agreement? This one, first point. Both parties decide it is in their mutual best interest to settle via a significant payment from the patent owner or branded to the generic to keep the generic drug off the market. The generic may make more money than by rushing to market the drug. The branded may also make more money by paying the generic to defer marketing the drug for a certain period of time. এখানে এটা কিন্তু ইম্পর্টেন্ট, ফর এ সার্টেন পিরিয়ড অফ টাইম, লাইফ লং কিন্তু এটা হবে না। সো দিস ইজ অ্যাবাউট রিভার্স পেমেন্ট এগ্রিমেন্ট। এখানে দেখো সাইড ডিলস টোটাল 6 আর দেয়ার। ইন্টেলেকচুয়াল প্রপার্টি আইপিআর, intellectual property license, co-promotion arrangement, supply arrangement, no authorized generic, development agreement, and distribution agreement. All these are the side deals for reverse payment agreement. Okay, IPR, co-promotion arrangement, supply arrangement, no authorized generic, development agreement, and distribution agreement. Here I have given one case study about this reverse payment agreement. See that FTC and Cephalon. It was filed in February 13, 2008, and the name of drug, that is Provigil. $800 million brand sale, but it has taken delayed entry almost 6 years. Why? The complaint alleges that Cephalon unlawfully induced 4 fast fillers to refrain from marketing generic Provigil until 2012 by entering into over 13 side deals that transferred substantial value of the generic. Okay, so that is one case study. From this, you can easily understand what is the meaning of reverse payment agreement. This is one settlement alleged delay entry by 6 years. The same example, when Provigil got FDA approval in December 1998, and after that, after April 2015, 3 years of patent. Okay, 3 years off, 3 বছর off থাকলো, and generic entry that is completely delayed by 6 years only because of this one reverse payment agreement. Settlement times, terms and ওটাই in details এখানে বলা আছে, এটা ডিটেলস এ যাচ্ছি না। ওকে, এগুলো সবই various examples are there. VMS, Apotex, settlement on Plavix, different case studies I have given here. Okay, then some litigation. What is the meaning of that? Brand sues generic for patent infringement, and court find for generic often on some litigations and hold patent invalid or unenforceable. This Hatch-Waxman 30-month stay, which allow brand to win even if they lose. That is the benefit of some litigations, which plaintiffs must prove brand's infringement suit, which is objectively and subjectively baseless. What is the meaning of some citizen petitioning? Companies can petition FDA to not approve an ANDA, which should be based on safety or formulation concern. So কোনো একটা ANDA apply করা হলো, করার পর দেখা গেল আরেকজন কিন্তু সে বলল যে এটা কিন্তু সেফটির উপরে মেনলি আমাদের জোর দিতে হবে, কিন্তু সেই জায়গাতেই দেখা গেল যে ফর্মুলেশন পার্টে কোনো রকম প্রবলেম আছে যেটার কারণে সেফটি ইস্যু হচ্ছে। সেই জায়গায় company can petition FDA to not approve an ANDA. Okay. Then citizens petition delay approval of ANDA, which is ripe for abuse and often abused. Delay itself is the goal. অনেক সময় এটাও হতে পারে কি আমি চাইছি যে ওটা একটু দেরি হোক। Then same standard as some litigations. Worker process fraud. Antitrust violation premised on fraud on the PTO. Patent applicants have a duty of candor to PTO because applications are expiring, which elements track fraud claim, often coupled with some litigations and other theory. এগুলো অ্যাকচুয়ালি আমাদের একটু এগুলো বুঝতে অসুবিধা হচ্ছে, আমি বুঝতে পারছি। এগুলো এরা এনডিএ অ্যান্ড এএনডিএ যখন আমরা হাউ টু অ্যাপ্লাই ওটা যখন পড়বো তখন এটা আরো ক্লিয়ার হয়ে যাবে। হোয়াট ইজ দ্য মিনিং অফ প্রোডাক্ট হপিং? Delay sometimes allow brand to introduce new version of the product, which changes are often minimal, but it can defeat generic competitions. Brand actively convert the market, resample and pulling the old product from the market. That is known as product hopping. So what are the various loopholes in the Hatch-Waxman Act? Authorized generics, 30-month stay, warehousing patent, and reverse payment and citizens petitions. All these are the various loopholes of this Hatch-Waxman Act. What is the meaning of authorized generics? Authorized generics are pharmaceutical products that are approved as brand name drugs but marketed as generic drugs. Okay, that is known as authorized generic. That are pharmaceutical products that are approved as brand name drugs but marketed as generic. That authorized generic do not bear the brand name or trademark of the brand name drug or manufacturer, but the brand name and authorized generics product are manufactured to the brand specification. Specification that will be according to the brand. Authorized generics have a unique impact during the first 6 months of generic competitions, and this competition from authorized generic during the 180-day exclusivity period has the potential to reduce both generic drug price and generic firm revenue. That is known as authorized generics. See that? That is how much number of authorized generics are there year wise. Here I have given one data. Different data are there of different company and different product. Okay. Here I have also one given example I have given. See that drug nitrofurantoin, innovator PNG, and authorized generics Watson, generic Mylan. Mylan lost about 30 million of the revenue it was set to realize under its 180-day exclusivity grant from FDA. Okay. Next, Indian companies and authorized generics. Example, see that Lupin in 2011, Femcon Fe, Warner Chilcott. Then Rucaltrol, Ranvaxi, Caduet, Ranvaxi, DRL, Joker. Okay, all these are the various authorized generics of different Indian companies. Last one, warehousing patent. It is evergreening or warehousing of patent. An innovator may patent multiple attributes of a product that may be color or manufacturing process or the chemical produced when the drug is ingested in the body, and it keeps on adding patent in the Orange Book, essentially forcing the generic to host between waiting for the patent to expire or file a para IV certification, which brings along the risk of litigation and which is associated with the cost and this delay. The provisions of filing a patent infringement lawsuit which gives the brand name manufacturer an additional 2.5 years. এর আগেও আমরা দেখলাম 2.5 years of product monopoly has resulted in a wave of such lawsuit. That is known as warehousing patent. Finally, we can conclude the Hatch-Waxman Act. It is extended the life of the pharmaceutical patent up to 14 years from the time the new drug application is approved by FDA. It also provided additional market exclusivity for the new uses or new formulations. It also allowed potential generic manufacturer to conduct work which is related to marketing approval of the drug without the charge of patent infringement. It also permit generic manufacturer to use safety and effectiveness research performed by the brand name pharmaceutical companies. And it also introduced the concept of bioequivalence to obtain the approval of generic drugs and simplified generic drug approval process by introducing ANDA. And it also encouraged patent challenges by providing 180-day market exclusivity for the first generic manufacturer who files ANDA. Okay, so all these are the various conclusions we can say after completion of this Hatch-Waxman Act. Some other conclusions are also we can say that is this act led to the birth of generic industries. It also gave protection of innovators in time of 30-month stay, market exclusivities, and patent term extension. But the brand companies are taking advantage of this loophole of Hatch-Waxman Act in the form of authorized generics, already I told, and reverse payment agreement. Okay. Brand companies are also involved in some litigation to take advantage of 30-month stay provision. The role of both brand and generic companies are vital for US healthcare system. And also it tells that maintaining the balance between these two important contributors to the healthcare will be essential in meeting the goal of affordable healthcare and innovative research. Okay. This is all about the Hatch-Waxman Act. আচ্ছা, এটা কি তোমরা তোমাদের এগুলো I think after completion of this you have to prepare one report, তাই তো সুরজ?
Yes, sir.
তো এটা কি আমি তোমাদের কিভাবে দেব স্লাইডটা?
ক্লাসরুমে
গুগল ক্লাসরুমে দিয়ে দিন।
গুগল ক্লাসরুমে দিয়ে দেবো?
হ্যাঁ স্যার।
ওকে, ঠিক আছে, তাহলে গুগল ক্লাসরুমে দিয়ে দেবো। না অ্যাকচুয়ালি এখানে যেটা এটা গ্রেড লার্নিংও দেওয়া যায়, কিন্তু আমি ওটা বুঝতে পারছি না এটা কোথা থেকে। অ্যাকচুয়ালি অনেক এতে এত অপশনস আছে যে আমরা
স্যার
কোশ্চেন
ক্লাসরুমে দিয়ে দিন স্যার, গুগল ক্লাসরুমে দিয়ে দিন, ইজি হবে। কারণ গ্রেড লার্নিংটা আমাদেরও বুঝতে একটু প্রবলেম হচ্ছে, আর মানে কোন ফ্যাকাল্টি কখন কিছু পোস্ট করছে না ঠিক বোঝা যাচ্ছে না, খুব প্রবলেম হচ্ছে।
হ্যাঁ অ্যাকচুয়ালি এটা কি বলতো, পুরোটাই আগে কি হতো, আগে শুধু জুমের থ্রু হতো, তো ওখানে আমরা কি করতাম তখন ওই একটা হোয়াটসঅ্যাপ গ্রুপের মধ্যে আমরা দিয়ে দিতাম লিঙ্কটা, ওই জন্য তোমাদের সুবিধা হতো বুঝতে। কিন্তু এটা কি, এগুলো সবই হচ্ছে যে যখনই এখানে শিডিউল করছে ক্লাসের, ওটা তোমাদের মেলের থ্রু যাচ্ছে। এবার কেউ যদি ধরো মেলটা মিস করে গেল তাহলে কিন্তু তার ক্লাসটা মিস হয়ে যাচ্ছে, ওটা বুঝতে পেরেছো? আর এখানে একটা জিনিস যেটা আমাদের যেটা অ্যাটেন্ডেন্স যেটা দেখছিলাম, ওইটার ক্ষেত্রে আমাদের সুবিধা হয়েছে, কে কতক্ষণ ক্লাস করলো, কে কখন হলো, এভরিথিং সবকিছু ওখানে ডিটেলস মানে অটোমেটিক ওটা হয়ে যাচ্ছে দেখতে পাচ্ছি। এবং পরে ধরো আমার কাছে এই যে ক্লাসটা আমি নিলাম, ঠিক 1 ঘন্টা পর আমার কাছে একটা মেল আসবে কতজন কে কে প্রেজেন্ট আছে, কে কে অ্যাবসেন্ট আছে, কে কতক্ষণ ক্লাসটা করেছে, এভরিথিং। এই দিক থেকে একটা সুবিধা হয়েছে, কিন্তু এই কোশ্চেন পেপার বানানো বা এগুলো ওটা এখনো পর্যন্ত আমি দেখে উঠতে পারিনি, আর কিভাবে কোথায় নোটটা দেবো সেই জন্য জিজ্ঞেস করছিলাম। তো তাহলে আমি এতেই দিয়ে দিচ্ছি গুগল ক্লাসরুমে, ঠিক আছে?
হ্যাঁ স্যার।
ইয়েস স্যার।
ওকে, ঠিক আছে, তাহলে আজকে এখানে শেষ করলাম ক্লাসটা। কারো যদি কোনো কিছু জিজ্ঞেস থাকে বলো, আমি যাও। ওকে, ঠিক আছে, থ্যাংক ইউ অল।
ওকে স্যার।
করলাম এখানে, ঠিক আছে। এরপরে
Okay.
আমি তোমাদের অ্যাকচুয়ালি টাইম টেবিলে আছে বুধবার, কিন্তু বুধবারটা আমার একটু প্রবলেম হয়, তার কারণ আমার কলেজ যাই তো একটু টাইমিং এ একটু প্রবলেম হয়ে যায়। তো সেই জন্য আমি ওটা প্রত্যেক ওটা থার্সডেতেই করেছি। যেমন আজকে 3 তারিখ, এরপর 10, 17, 24 and 31, ঠিক আছে? এভাবে প্রত্যেক বৃহস্পতিবারই নেব।
ওকে স্যার, ওকে, নো ইস্যু।
থ্যাংক ইউ।